But I want to take you back to this conversation. We've been in conversation earlier on with Yolanda Mnyengeza, who's an attorney on marriage law, very specifically on the implications it have. Because marriage isn't just about love, it has legal implications that can affect your future, from customary marriages and lobola traditions to advantages and risks of difficult contracts. Understanding your options are then essential. Let's continue this conversation now with Yolanda. And I want to encourage you to give us a call on 011 714 0661 or 0662. I want to repeat that number for you. It is 011 714 0661 or 0662. And of course, you can ask Yolanda any question, and you perhaps can share your story and or experience with us on the line. So do give us a call. Yolanda, welcome back, and I want to continue the conversation here. I want us to talk about other parts of family law and your affairs, financial affairs, that can affect the marriage contract. And yeah, I very specifically want to speak about trust and trust beneficiaries, particularly pertaining to children, either of that marriage or preceding that marriage, or extramarital children who may have a claim to a trust when either one of the parents who in this marriage pass away. What effect does the marriage contract, whether in community of property or outside community of property with accrual, what effect does that have on the dispensation of a trust and the assets of that trust?
Okay, so Oliver, when you're speaking about a trust, you're speaking about something that is totally independent to an individual. So a trust has its own beneficiaries, it's got its own terms and conditions. So if, for example, you do get married, and by the time you get married, you already had established a trust, it will now depend on who the beneficiaries are. If, for example, the children are specified, they will obviously benefit there. However, if your spouse is not there, then it means that that trust operates independently to that spouse, meaning that that particular spouse does not necessarily have a financial claim to that trust. Remember, this is something that's totally separate to the individual. So the individual cannot also be seen as that one trust. So if for anything the spouse wants to claim or is requesting to also be a party to that trust, they need to have some form of claim. Let's say the trust was created during the marriage, and maybe the financial assets of the marriage were actually the ones that were utilized to start or are operating in that particular trust. In that instance, then a spouse can say, I would like to also get access to the financial assets of that trust, or make a claim there. But then again, they also would have to prove that the actual financial assets belonging to the joint estate were the ones utilized to establish that trust or in operation inside of that trust. But if this trust has got nothing to do with this individual who you're married to, they cannot have a claim to it. This is also applicable where people, let's say, are divorcing now. They cannot say, I want those assets that are locked in that trust to also be considered in this divorce, because that person does not own those particular assets. They now belong into that entity, and they are beneficiaries that are the ones who will benefit in that trust.
Let's talk about wills and the effect thereof in the instance of death. So assume a married couple, and there are children party to this marriage, and let's assume one or two of the children precede this marriage or are outside of this marriage. When a party dies, of course, their will takes effect, and they may elect to bequeath their assets to their children, and especially if it's children preceding or outside of this marriage. What consideration is given to the marriage contract vis-a-vis the will of the party that passed?
All right. So this will depend, Oliver, on the type of marriage these parties had. Was it a marriage in community of property? Was it a marriage out of community of property? Because now this is going to make a difference as to how the assets are going to be inherited. If it was a marriage in community of property, unfortunately, it doesn't matter what the party had said in his will. Not everything that he, for example, would have purchased utilizing his own funds, etc., will go to the children, but rather the 50% that he or she was entitled to is going to be split and given to the children. If, for example, he has nominated or she has nominated that all of his or her things must go to his or her children. Then the surviving spouse is going to get the remainder of the 50%. So often there's this misunderstanding that people have that if I, for example, though I'm married in community of property, if I had acquired a certain property or certain properties, I can bequeath them the way in which I want to because irrespective, I had purchased them. But then they forget that when you get married in community of property, you join everything, whether acquired before the marriage, utilizing your own funds, or else they were acquired during the marriage, also still utilizing maybe money you got from your own employment. It doesn't make a difference. It now forms part of this joint estate. So you can only now speak to the 50% of that joint estate when you are leaving or bequeathing any assets to your beneficiaries.
Yeah, give us that call. The number is on your screen right now, 011 714 0661 or 0662. Are you perhaps going through what is a very temperamental and acrimonious divorce where questions around the nature of your marriage contract perhaps are top of mind for you? Give us a call, share your experience with us, and maybe Yolanda can advise you on what your options are. 011 714 0661 or 0662. Yolanda, I want to take it to this now because I think it's quite clear from the explanation that you give that the marriage contract seems to take precedence over what is in your will if there's a contradiction or if you seek to bequeath assets that are the property of the union in the will. Let's talk about things such as future unrealized assets, and pension funds are a big example of this. Now, that's part of your estate in the consideration of a divorce. But if you divorce after the fact of a pension fund having cashed out, we saw a very interesting case of that nature last year. What recourse, and of course the spouse that then claims their half thereof, so to speak, would have to go through the right channels. For instance, they'd have to get a tax decree from SARS in order to be able to access the pension fund. Would it be considered an illegal act if a spouse cashes out their pension fund during a divorce and does not share that portion with the spouse that they're divorcing from? What implications does future unrealized assets have in a divorce or in a marriage contract?
So, as we know, once you're married in community or property, everything is shared equally. You jointly own everything, and this includes pension funds. So if there's an attempt to withdraw, as somebody actually withdraws this pension fund, just at that time when the parties are about to divorce, this is obviously unlawful because this is meant to be considered in that particular divorce. So if this happens, it is recommended that the spouse who is the victim of this to bring it to the attention of the court. For example, to clearly state that in the distribution here, we need to consider the fact that the spouse has now already withdrawn these funds, meaning that I am now at a disadvantage, in a sense, requesting that the split not be done 50-50 in a sense because now we're missing a pension fund, that it be considered that there's a loss that took place here because the spouse actually withdrew the whole amount and they did not benefit from it. So these things can get a bit tricky during divorce, which is why people always have to keep tabs of what their spouses have and during that time of divorce to ensure that they quickly speak or notify pension funds in a case of divorce that this is what is happening, be aware of it so that this spouse does not get the opportunity to unlawfully withdraw those funds. So these are things that people just need to be aware of, which is why it's always important when you're thinking about getting a divorce of any nature, you go speak to your legal practitioner so that the necessary action can be taken and on time. But then again, obviously, when somebody dies and the pension fund is yet to be cashed out, that's an entirely different story. And as you probably are aware, it's not necessarily dealt with as per the instructions you're going to give out in your will. So this is something that's definitely dealt with in terms of the Pension Funds Act. So the Pension Funds Act really isn't concerned about estates, etc. The trustees just have to determine who are the legal and factual dependents, who was the deceased, who had this pension fund responsible for, and to what extent were they taking care of these people, whether it be the spouse, whether it be the children, everybody's going to be qualified. And also mistresses at times may just be qualified to also get a benefit here. So it's very critical to understand how these things operate to someone who's married, potentially to someone who does have a pension fund, so that if anything happens, whether during the time of divorce or at death, you know exactly how these things are going to be handled and what it is that you can expect.
Let's talk about that. Under what conditions can, say, a mistress claim benefit from the estate of a married person, someone that they're not married to?
So this can essentially happen where the deceased was actually taking care of the mistress. So the mistress, in a sense, was dependent on the deceased, in that the deceased was providing certain support in the form of, let's say, i.e. rental. If they needed to go to the doctor, they were helping them. Any other form of support that can show that there was a dependence between these two parties, that will enable the mistress to actually have a claim on that particular pension fund, meaning that there's going to be now additional beneficiaries, irrespective of a nomination form, maybe not including the mistress. The mistress may just have to be considered so that they can also get a share, because this deceased had created now a dependency relationship. And according to the Pension Funds Act, in this instance, this person may just need to be qualified as a factual dependent and get a share. Whether that share is going to be above that of the children is another story.
What is the standard jurisprudence on the entitlement? Once it's been established that the mistress does have an entitlement to the estate, what percentage typically is it, or is it judged on a case-by-case basis?
Well, it's on a case-by-case basis, Oliver. What the trustees will do is they will look at a number of factors, i.e. the kind of dependence that this person had on the deceased. What were they doing? What was the deceased doing for them? And are they able to now do for themselves? Do they work? How independent are they, right? The impact is also going to be looked into. And now there's going to be a comparison as to the other dependents as well. So it does happen at times that the mistress may just get a bit more than children. We've seen it happen, right? And sometimes the spouse's percentage may just, the surviving spouse's percentage may just go lower, because we need to now qualify and provide a certain percent to the surviving mistress as well. So this is something that we cannot deduce or determine prior. It's an inquiry that the trustees will do and then make a determination on that basis.
I want to bring in a caller at this moment, Musawenkosi in KwaZulu-Natal. Musawenkosi, I hope you can hear me loud and clear. Go ahead. What's your comment or question?
My comment here, I just wonder why South Africa, since the apartheid dispensation, you just get to democracy. But you are still creating more things from the Western style to us. Now you are telling us about now recently men can just adopt the female and stuff. Why don't you bring us back to our culture? A man has got 20 wives. You see, there's a child there who are called Inkosana. Inkosana must be able to be guided by the laws of us as black people to just divide my belongings to the entire family. Why do you bring all these things, come with these new things, the marriage and stuff? What brought the marriage in the first place here in us? Because the white people,
I'm going to have to...
They tell us how to live in our culture. If we are free and fair, just guide the law to our culture as before the apartheid comes.
Yeah. Musa Mnyengeza, I'm going to have to stop you there because I do think we've gotten... Yeah, Musa Mnyengeza, we've gotten the gist of the...
Every year, they don't change into the marriage.
Yeah, Musa Mnyengeza, I'm going to have to pause you there because I think we have the gist of your question there, and I do want to give other callers an opportunity and give Yolanda an opportunity to respond to your provocation there. Let's go to Tembisile in Makanda in the Eastern Cape. Tembisile, go for it.
Good morning to the program and to all the viewers. My question, I've got a property that is registered under my company, which is a farm, and I would like to establish a trust and then transfer this property from my business to the family trust. I just want to know, in terms of the law, am I allowed to transfer this property to the newly established family trust?
Beautiful question. Thank you so much. Yeah, thank you so much.
And we are married in community of property, and we do have consensus on this.
Okay. Thank you so much. Beautiful question, Tembisile. Really appreciate it. Please do listen back on the television. Do you want to go for that, particularly on Tembisile's question, Yolanda? They've got a trust. They're married in community of property. He's a business owner, and there are properties owned by the business. He wants to transfer those properties into the family trust, and there's consensus between himself and his wife. What are the legal considerations here?
All right, so in this instance, this should be a fairly simple transaction. It is definitely allowed for them to transfer that property out of that business into the trust. But the only question I would have or concern that I would raise is who currently really owns the property, in a sense that does it not have a bond attached to it? Because if it does have that, they might just have to start with the institution that has provided them with such a bond so that they can get the ability or the authority rather to move this property into the trust itself. But if this is allowed and the business owns it without any there's no bond attached to it, then it can certainly be done. It's not going to be a very tricky process. They just need to approach a legal practitioner and they can then do that transaction fairly easy.
Yeah. I don't want to dismiss Musa Mnyengeza's provocation, albeit it was quite parenthetical to the nature of the conversation that we're having here. But there seems to be a continuous tension between customary law and the common law. At what point does one become applicable over the other in contestation of marriages and related to marriage contracts?
Okay, so in South Africa, we've got a rank of different laws that need to be considered. We've got the constitution at the top, we've got the legislation, and then we've got your common law, and then we've got your other customary norms that people utilize. So if there is a legislation that speaks to a certain aspect of the law, i.e. how marriages come about and what it is that is required in order for a marriage to come into light, then that legislation will be applicable and not the norms and the other aspects of the law, i.e. your common law, right? So the legislation is ranked right there at the top. And I just want to point this out to Musa Mnyengeza that as much as it may seem as though the cultures are not necessarily considered, most of the legislation, if you have a look at them, look at the Recognition of Customary Marriages Act, you look at the Matrimonial Property Act, etc., you'll find that they are trying to equate the two parties at all time, women and men. Because if you look at the common law or the cultural ways of doing things, they often put aside the interests of the women and children and specifically put forward the interests of men, in a sense, giving much more flute to the patriarchy system. So now these legislations that have been put in place are trying to address some of those issues, the uncertainties and the lack of benefits that women used to get in the past. Obviously, yes, people will not agree with them, but to a certain extent, they are trying to heal a certain aspect of society that had always been injured because of the imbalances that exist in culture and all of these norms that have been practiced in the past.
Let's talk about the termination of marriage contracts. It's a contract, and every contract has an exit and termination clause. It's a standard part of contract law. The parties getting married can debate and decide what that looks like. And of course, oftentimes parties use this as an opportunity to insert certain safeguards for themselves into this. For instance, if one party is guilty of infidelity, for instance, the other party would be entitled to 80% of their estate, or whatever the case may be. What level of legal validity do those carry in South Africa, and how often is it important to test the constitutionality of negotiated termination clauses before signing them?
Very important, because a lot of people want to insert a lot of clauses which are against public policy. For example, if you just cheat on me, or if you don't give me this, then it's going to mean that you are at a disadvantage and then I am at an advantage. So some of those don't necessarily operate in South Africa, right? Or else they still need to be tested before the law so that they can be qualified if they really are suitable under a constitutional dispensation such as that of South Africa. For example, we stepped away in South Africa from the fault aspect of, let's say, when people are divorcing, because back in the day, it used to count a lot the fact that a person had cheated and the marriage had come to an end because of that, and then that person would be faulted. We moved away from that particular system because we are now currently under a constitutional dispensation. So some of the terms need to really be qualified, which is why people need to go to a legal practitioner and have a discussion with them. If I want to include this, is it going to be a possibility? Because if you include certain aspects in that contract, which are against public policy, against the Constitution itself, they're not going to be operated at the time of you guys getting divorced. So it would make sense to then get what? Get the proper advice and information before you even try and sign that contract and think that you are safeguarded by the terms of that contract.
We have another caller on the line, Paul in Limpopo. Paul, go for it. Good morning.
Even try and sign the contract and think that
Paul, before you come on, I'm going to ask you to switch off or lower the volume on the television, mute it entirely or switch it off so that we can hear you loud and clear. Hopefully you do have it down now. I can still hear an echo of myself, so certainly not yet the case. I'll put Paul back to our technical room so that they can sort that out. I'm in conversation with attorney Yolanda Mnyengeza. Let's speak to Split in Kagiso in the meantime. Split, good morning. Go for it.
Morning, how are you, sir? Good morning, attorney.
Yeah, go for it.
Yeah, actually, I have a question here. You know, I have a challenge. I just want to find it, to get the clarity here. Because I have a brother who passed on actually. He was married to a wife, and he was having another child to another woman. So after he has passed on, the first wife withdrawn the money of the other child, was of the other lady. So I just want to find out from the attorney to say, how can he assist me on that?
Yeah, thank you so much for that question, Split. Yolanda, do you have a response for that?
Okay, I didn't really get him clearly, but I heard him talk about two children. One's funds were withdrawn. I didn't get the other aspects. Can you help me there, Oliver?
Split, do you want to clarify that for Yolanda?
Yes, you know, my question is that I have a brother who passed on. He was married to a certain wife. So he was having another child to another lady.
Okay, so for clarity, Split, just slow down. Can I just pause you there, Split?
To claim the money from the GDPF. It was said from the GDPF, they were saying that the wife has claimed that money. So I wanted to get clarity from the attorney.
Okay, I get it. Thank you so much for that, Split. Really do appreciate it. Split's brother was married and had children outside of that marriage. His wife then claimed his pension fund, and when his children sought to access the pension fund, they were told that his wife had carried out the withdrawal. Are there any recourse for the children in this instance?
Yeah, that's a bit of a difficult one because now they've gotten access to everything. So if anything, they will have to go after that particular spouse to try and recover those monies because she unlawfully got access to the rest of the funds. that were meant for these children. But then again, it's going to really be on the fact that was she aware that there were other children there? But that's something that they can pursue, but only against the wife, because the pension fund really depends on the people that come forward in order for them to gain knowledge as to the number of children that are actually there and should be considered for a payout.
Yeah. Let's go back to Paul in Limpopo. Hopefully Paul's ready for us this time around. Paul, good morning. Go for it.
Yeah, how are you?
I'm fantastic, Paul. Go for it.
Yeah, no, you are speaking to.
Paul, we can hear you. Go for it.
Yeah, good morning, and how are you? Yeah, you are speaking to Paul from Limpopo. I have a question of my friend here. It's not about, it's just about the divorce, but it's not about the pension fund. So this friend of mine is married with 3 children, and it's just unfortunate because of rape of the other one. Then he was in jail for some couple years. Then when he came back from jail, after 15 years, when he came back, so this wife of him, then she's married by the other man, and his wife didn't apply for a divorce. Now this guy, he failed to marry the other wife because of his wife. So I don't know in this case how can we sort it out, because now the guy is a single man now.
Okay, thanks for that. Really do appreciate you. I think I do get it, Paul. Yolanda, married to a wife, doesn't want to be with the wife anymore. She doesn't agree to the divorce, and so there's recalcitrance between the parties. He moves on with his life, finds a new partner and wants to now marry her, but is unable to do so because he's still married to his first spouse. What can be done in that instance?
Okay, so in this instance, the party that wants out of that marriage can just simply either go to the court and start filing for a divorce, or get an attorney to assist them to file a divorce. So in South Africa, you don't necessarily need the other party to agree to a divorce. If they don't want for you guys to amicably pursue this divorce, then you've got the option of actually ensuing this on your own. They will get notification, obviously, that you are trying to divorce them, and they will be given an opportunity to come forward if they want to defend that. But the court then will make a decision and provide you with the divorce that you're looking for on the terms that the court will decide on. But you don't necessarily need the other party to agree to it. If they don't want to, then it's for you to go to the court on your own to file for divorce, or get an attorney to help you with this. Yeah,
we're going to have to leave it there for now. Yolanda Mnyengeza is an attorney talking to us about marriage contracts and the legal implications of marriage considerations in the instance of divorce, and of course, as you start your marriage.